Well, welcome everyone, and thank you for joining us virtually this evening for what we hope will be an informative presentation for landlords and tenants in the City of Richmond. My name is Cynthia Shaw, and I am the Assistant Administrative Analyst. Today, Rent Program Staff Attorney Palomar Sanchez will be conducting this evening's presentation. Before we get started, I would like to share some logistical information. Please note this presentation has been posted on our website at www.richmondrent.org/workshops for your reference. I will provide that link in the chat on the bottom of your screen. Please note also that this presentation is being recorded, and we hope to post the recording on our workshop page as well. If you have any questions on a particular topic discussed today, we ask that you type your questions into the Q&A function on the bottom of your screen, and we will address your questions at the end of the workshop. If you have specific questions on a particular issue, we ask that you contact the rent program and discuss your questions with one of our rent services analysts. I will also provide that information on how to contact our office in the chat as well. Without further ado, I would like to introduce you to Staff Attorney Palomar Sanchez.
Thank you, Cindy. And thank you everybody for joining us this afternoon, early evening, for what I hope to be an informative workshop. Just first of all, I just want to clarify, I understand that evictions right now are, they're just more complicated than normal. And I also surmise that many of your questions are probably going to be specific to your situation. And, I just have to preface before we get started that I cannot answer or provide legal advice. I can give you, what this is a very broad overview of, these processes and laws that are applicable to evictions. However, just understand that there may be questions I just cannot answer for you. Either one, because the answer would, require some fact digging, and I would like to or me or someone in the rent program staff should probably ask you some further detailed questions to get a sense of the situation and that so they can properly answer. Or it's just straight up legal advice where I definitely cannot answer those types of questions. I already saw in the Q&A that there's some kind of very specific questions like how to do things and should someone do this or that. Some of those questions are legal advice. So I'm just letting you know I can't answer everything. In any event, we'll see how it goes at the Q&A at the end. So let's just get started. So this is navigating the eviction process in Richmond. As Cindy indicated, I'm a staff attorney for the Richmond Rent Program. And I hope that you find this informative. All right. So the first thing I want to give in terms of information is a community update. So on March 23rd, 2021, the Richmond City Council, again, the City Council, not the Rent Board, adopted Urgency Ordinance number 02-21. You can call it the Eviction Moratorium, establishing a temporary moratorium on certain evictions of residential tenants in Richmond through the local emergency and 60 days thereafter. So again, this doesn't actually have an end date. It just depends on when the local emergency is declared, to be over, and then you add 60 days, and that's as far as this ordinance goes. Now, during the local emergency and continuing for 60 days after, landlords are prohibited from evicting tenants in most circumstances except for the following. So again, cannot do evictions except for the following. So one is a nuisance that poses an imminent health or safety threat. Nuisance is a catch-all, and it is one of the just causes. But again, this ordinance somewhat alters that. It has to be a nuisance that poses an imminent health or safety threat. Second, the tenant has failed to pay rent that became due between March 1, 2020 and June 30th, 2021, pursuant to the COVID-19 Tenant Relief Act. So even though this is one of the allowable reasons to evict, any eviction for non-payment of rent would still have to comply with all of the requirements set by the COVID-19 Tenant Relief Act. And that is state law, so we have no say over it. And I will get into some further details about the Tenant Relief Act in some later slides. And then finally, the last allowable eviction or a reason to evict under the urgency ordinance is a termination to remove the residential real property from the rental market, which is otherwise known as the Ellis Act, but it only authorized by Government Code Section 7060, which is the state code for the Ellis Act. And you must also follow the requirements of Chapter 5 in the Richmond Rent Board regulations. So again, no evictions unless they are a nuisance that pose an imminent health or safety threat, non-payment of rent, but you have to follow the requirements of the COVID-19 Tenant Relief Act, or an Ellis Act eviction, but you still have to follow the requirements of Chapter 5 Rent Board regulations. All right. Lastly, what this urgency moratorium added was a notice requirement. And there's an asterisk there because this additional notice doesn't apply for cases of eviction for non-payment of rent, because the state has already stated certain notice requirements. And so if it's for non-payment of rent, you have to follow what the state says. But if it's for either of the other two reasons that are allowable right now, you have to include this language, and it's verbatim. It says any notice of termination of tenancy served on a tenant with respect to a residential unit during the local emergency and 60 days afterward shall include the following statement in bold, underlined 12-point font. An emergency eviction moratorium is currently in effect, other than for failure to pay rent, an imminent health or safety threat, or to remove the residential real property from the rental market, but only when authorized by Government Code Section 7060 et seq. Residential evictions are restricted during the local COVID-19 emergency declared by the City of Richmond. Residential tenants who are being evicted for failure to pay rent may have additional protections under California law. You may contact the Richmond Rent Program at 510-234-RENT or 7368 for additional information and referrals, or visit www.richmondrent.org. All right, so putting aside, and by the way, I will intermittently throughout the presentation, I'll be talking about, some of the other laws that are applicable here, including SB 91 and the Contra Costa County Urgency Ordinance. It's a little difficult to know exactly, where to put that, but some of these slides are for normal times, like when things kind of, quote unquote, go back to normal. And other slides are, how they are now. And I'll do my best to kind of explain, the difference between the two. But for now, this is just kind of some general information about the Richmond Rent Ordinance. So first of all, the purpose of the Richmond Rent Ordinance. So it's called the Richmond Fair Rent, Just Cause for Eviction and Homeowner Protection Ordinance. That's the long name for it. It's also known as the Rent Ordinance, and the purpose of which is to promote neighborhood and community stability, healthy housing, and affordability for renters in the City of Richmond by controlling excessive rent increases and arbitrary evictions to the greatest extent allowable under California law, while ensuring landlords a fair return. All right. Now, this is a broad overview of what the Richmond Rent Ordinance does. Obviously, there's a lot more, but this is more just kind of big picture items. And as you can see, there's really two prongs, right? One is rent control on the left, and then the other is just cause for eviction protection. So we'll start with the rent control side. So first of all, what rent control means that rents are regulated. The maximum allowable rent, which is we call the MAR, is calculated by taking the base rent, excuse me, and then you add in annual general adjustments, which is the cost of living increase or inflation, plus any allowable individual rent adjustments that is ordered by a hearing examiner. And that's only through the petition process through our agency. And if you see under that box, right, there's one part that says annual general adjustment, which is 100% of the consumer price index or CPI of the Bay Area. And that's how we calculate, which are produced by the federal government. That's how we calculate what the AGA will be every year. Then there's the petition process, which is, as it says here, a mechanism to increase or decrease the MAR, again, the maximum allowable rent, based on reasons permitted by the rent ordinance. And finally, the base rent, and maybe I should start with that. The base rent, if you need to know how to understand what that is, it depends. So if a tenancy was in effect in 2015, then you say, all right, well, the base rent is the rent in effect as of July 21, 2015. That's how you figure that out. Now, for newer tenancies, anything after that date, the base rent is going to be the first rent charge for tenants that moved in after that date. So let's just say they moved in, February 17th in 2016. Well, that's going to be the base rent. Whatever you first started charging that tenant or that household, that's the base rent. Now, the other side of the rent ordinance is the just cause for eviction protection side. So, and this is very common in most rent control jurisdictions. You see, one prong is always going to be rent control, or almost always, and the other is almost always going to be just cause for eviction. And so what this means is that for properties that are covered under just cause, a landlord needs to have at least one of the 8 just causes to terminate a tenancy. If it is not stated here, then you cannot terminate the tenancy. So 1, failure to pay rent. Now, as I already said, that's still currently subject to the SB 91 and the COVID-19 Tenant Relief Act. 2, breach of lease. 3, nuisance. 4, failure to give access. And that's failure to give access when the landlord had a lawful right to do so. So there are requirements that under state law that the landlord has to follow if they want to enter. And so, like, for example, giving proper notice, at least 24 hours, and having a proper reason under California Civil Code 1954. And then the tenant repeatedly denies access, so you can't come in. That could be a potential failure to give access. 5 is temporarily vacated in order to undertake substantial repairs. That one's a little bit unique because it says temporarily. It's not a permanent eviction. You must let them back in once the work is done. Number 6 is owner move-in or owner relative move-in eviction. That's where the owner evicts a tenant to either move in themselves or a qualified relative. 7 is withdrawal from the rental market, as I kind of mentioned earlier, otherwise known as the Ellis Act. And then number 8 is a temporary tenancy, and that's only applicable for single family homes where the landlord previously occupied the house as their principal place of residence, and then writes into the lease that tenancy cannot extend beyond 1 year. At the end of that year, the landlord can then move back in. Again, it's a temporary tenancy, a very specific type of eviction. So again, those are the 8 just causes, but as you'll see as I go on through the workshop, most of these are halted for now. Some exceptions, nuisance, rent, or failure to pay rent, and withdrawal from the rental market. Basically, everything else is on pause. All right, so moving on. All right, so this is a broad overview again of which type of properties are actually covered by the rent ordinance. And we'll start on the left side. This is fully covered units. So fully covered units means the unit has both rent control or rent regulation, and just cause for eviction protection. And what this is most multi-unit properties built on or before February 1, 1995. So basically, any apartment complex that is built before that date is probably going to be rent controlled. Then you go to the middle, and that's partially covered. Partially covered means there's no rent control. However, the just cause for eviction protections are still there. And so even though they don't have rent control, you must, in order to terminate that tenancy, you still must present at least one of those HS causes, again, in normal time. So some examples of these would be subsidized units, including Section 8 tenancies, properties with one dwelling unit on one parcel, which can be like a single family home, condominiums, and then anything that is considered new construction, which is constructed after February 1, 1995. And there's a small asterisk there because Costa-Hawkins state law requires that the units be permitted with a certificate of occupancy in order to be considered like new construction. All right, the last one is fully exempt. So this means there's zero rent control and no just cause. It's almost as if the property is not in Richmond, right? It just doesn't have any of those local protections. The state law ones would potentially still apply, but at least for our purposes, they wouldn't apply. So again, no rent control, no rent regulation, and no just cause requirements. So this is in the situation where the landlord and the tenant share a kitchen and or a bathroom, right? They live together. Also single family homes where there's a permitted ADU, and that means accessory dwelling unit, was added, and the main house is owner occupied, or retirement homes. So again, and that's it. That's the only three designations. You're either fully covered, partially covered, or you're fully exempt. That's it. All right. Now, compliance with the just cause for eviction requirements. So we're going to go briefly over some just causes for eviction, some noticing requirements, and the eviction process itself. All right, so again, just going over the just causes for eviction, residential tenants can only evict, again, this is in normal times, can only be evicted for one of the following just causes, and the notice must state the reason. Failure to pay rent after having been served a 3-day notice to pay or quit. So like, for example, right now, failure to pay rent is the most, problematic and, one that has the most restrictions right now. For example, and I'll go over this a little bit more, but, in normal times, it's 3-day. Right now, you'd have to serve a 15-day notice to pay or quit, along with a declaration and all this other stuff that's required by state law. But we'll get into that in a second. Breach of lease. So if a tenant continues to violate the lease after being warned in writing to cease the violation, that could be a breach of the lease agreement. Nuisance. If a tenant continues to cause a nuisance after being warned in writing to cease causing the nuisance. The nuisance can be all kinds of stuff, right? You can have, people who throw loud parties all the time. You can have, domestic violence issues, tenants threatening other tenants, aggressive dogs, all kinds of stuff. Now, whether or not your individual situation falls under a nuisance, that's up to the judge. You'd have to take it to court and see what happens. Failure to give access. So that's, again, I kind of briefly went over that. If a tenant continues to deny a landlord lawful entry per Civil Code 1954, after receiving a written warning notice to cease, denying the lawful entry, that could be one of the reasons to, say that could be a termination. Temporarily vacate in order to undertake substantial repairs, owner move-in, withdrawal from the rental market, and temporary tenancy. Those asterisks there for temporarily vacate in order to undertake substantial repairs, owner move-in, and withdrawal from the rental market, those asterisks are there because at the bottom you see there's a relocation payment required for those types of evictions. And we will go over those in some later slides, but those are required if you are endeavoring to evict for any of those reasons. All right, so written warning notice requirements. And so this is again under the, this is what's required under the rent ordinance. And so first of all, these notices, and we have templates for these on our website, and that's at the bottom. But these notices must, again, these are warning notices, not termination notices. They must be served prior to a notice of termination of tenancy if the just cause for eviction is one of these three things: breach of lease, nuisance, or failure to give access. The notice must provide the tenant with a quote unquote reasonable period of no less than 5 days to correct the violation prior to serving a notice to terminate the tenancy. It must state that the failure to cure may result in an eviction. It must inform the tenant of their right to request a reasonable accommodation. It shall include the contact number of the rent program. It shall include instructions for compliance, and shall include information necessary to determine the date, time, place, witnesses present, and other circumstances. And again, like I said, a template for this type of warning notice is available on our website at the URL you see at the bottom. You can use your own warning notice. It's not required to use our own, but we provide one just for for ease of use. All right. So these are the noticing rules for, again, continued on for the just cause for eviction. So this is more about the termination notices, not necessarily the warning notices. So landlords must submit a copy of any termination notice, any termination of tenancy notice served on a tenant within 2 business days of serving the tenant, along with a proof of service. So in that sentence, you see 2 requirements, right? You want to serve a termination notice, you must, 1, serve a copy of the notice within 2 business days to the rent board with a completed proof of service. If you don't do that, that could be a potential defense to the eviction. And so the termination notice should be submitted online. So there's the website. And for properties with 5 or fewer units, the landlord may submit the notice by mail. Again, here we go. Failure to file the termination of tenancy notice timely may be asserted by the tenant as an affirmative defense in an unlawful detainer eviction proceeding. So again, that failure to do so, you may be shooting yourselves in the foot, because even if you're correct on whatever allegations you may be putting in your paperwork, if you don't submit that copy within 2 business days, or you don't have that proof of service, that could potentially be used as a defense, and your case may be dropped. And be advised, and this is something I had to add this just because of the urgency ordinance in Richmond that was recently passed. Recall that pursuant to the passage of the Richmond Urgency Ordinance 02-21, landlords must include additional language for notices of termination, besides notices for non-payment of rent. So again, look at slide 4 if you want to know what that language is. But again, if the termination notice is for non-payment of rent, you don't have to include that language. You just have to use what is provided by the state law, the COVID-19 Tenant Relief Act. All right, so we went over what is a just cause. Let's go over briefly what is not a just cause. And, obviously this list is not exhaustive, but this is just some examples. So not just cause: the mere expiration of a lease agreement, especially where the contract says the tenant must move at the end of the lease. Now, so if they're just in an apartment and their lease just expires, you cannot evict a tenant simply because their lease agreement is over. The only exception to this one is if it's that temporary tenancy that I spoke of earlier. In that situation, and again, there are some additional requirements there, but you can ask the tenant to vacate at the end of the lease, but has to already be in the lease agreement, and that owner it only is for single family homes, and that owner would have already had to live in the unit as their principal place of residence prior to the tenancy. So what else is not just cause? The sale, transfer, or foreclosure of the property. So you're a landlord, hey, I want to sell my property, but I want to evict tenants because of the sale. That's not a just cause to evict. Not a just cause is another one is the tenant is paying below market rent and the landlord wants to evict the tenant to reset the rent. Definitely can't do that. Also, if the landlord makes a unilateral, meaning one-sided, change to the terms of the tenancy and the tenant violates that unilaterally imposed term. And finally, if the landlord unreasonably denies a replacement roommate, one for one placement, and then tries to evict for subletting or subleasing, also not a just cause. All right, so now we're going to talk kind of, that was just more of, general law as it relates to the Richmond Rent Ordinance in normal times. I just wanted to interject the COVID-19 Tenant Relief Act and go over that very briefly. So on or about January 28, 2021, the California legislature passed SB 91, which extended the state's eviction moratorium and added several new sections to the COVID-19 Tenant Relief Act. It was previously known as the COVID-19 Tenant Relief Act of 2020, but this new iteration removed that, obviously because now we're in the new year. And it did a bunch of other things as well, and I'll go over that. The COVID-19 Tenant Relief Act, the act, or also called the CTRA, is intended to coordinate the state's response to COVID-19 rent-related evictions, permit the courts enough time to adjust to the backlog of cases, provide tenants a clear, consistent path for obtaining protection from eviction when they cannot pay rent due to a COVID-19 related issue, and provide landlords with basic certainty on when they can collect the rent debt owed, and creates a process whereby it's easier for landlords to access the court to seek the debts owed. And by the way, there's quite a lot of information embedded in SB 91. If you want a more thorough exploration of this law, not only do we have fact sheets on our website about it, we have an entire page dedicated to COVID-19 related information and resources, but also there is a workshop that I presented, I think it was in September or August of last year. I think that was it. No, maybe it was later. Maybe it was earlier in the year. In any event, what it is, it's about just the COVID-19 Tenant Relief Act and other COVID-19 laws. And so there, if you go on the workshops page of our website, you can actually pull that up. And that's actually where I got these slides. All right. So under SB 91, the following applies only to residential notices of termination of tenancy for non-payment of rent served any time between March 1, 2020 and June 30th, 2021, which is called the covered period. So again, only for non-payment of rent, only for non-payment of rent. First of all, as I said earlier, you can no longer serve 3-day notice to pay rent or quit. It must be a 15-day notice, excluding weekends and judicial holidays. So when you think about it, when you don't include weekends, that's a 3-week notice. Has to be at least 15 days, excluding weekends and judicial holidays. It must contain an unsigned copy of a declaration of COVID-19 related financial distress with verbatim language provided by the state. Now, again, this language and the declaration itself is we have links to it on our website, but all that language is provided by the state. And if you do not provide this copy of this declaration to the tenant, then the tenant could raise that as a potential defense. Also, at the very least, it must be in the same language the lease was negotiated in. So English must be provided in English, Spanish must be provided in Spanish. The state has, or I think it's either the state or some other organizations that provided translated forms as well. And again, we have links to that stuff on our website. The notice must specify the amount owed and apportion it by month based on the date it became due. It must contain specific verbatim language from the CTRA. So there is like certain type of language that you have to look at And those small notes on the bottom says for notice to seek rent owed during the protected period, the language comes from, and I'm sorry, I didn't put the what type of code that is. It's California Code of Civil Procedure 1179.03 section B4. And the protected period means March 1, 2020 to August 31, 2020. And then the next part says for notices that seek rent during the transition period and were served before February 1, 2021, language comes from Code of Civil Procedure 1179.03 C4. The transition period is from September 1, 2020 to June 30th, 2021. And then finally, for notices that seek rent during the transition period and were served after February 1, 2021, the language comes from Code of Civil Procedure 1179.03 section C5. And again, there's quite a lot of other stuff, including late fees and security deposits and rental debt and all that stuff under the COVID-19 Tenant Relief Act. And again, like I said, we have more of that information on our website. So if you need to look at that, feel free to check it out. All right. So this is a very broad overview of the process on how it works when there's an eviction for non-payment of rent. Now, again, this is what it looks like in normal times, right? A lot of this is probably still going to be the same, but there are some changes. So I'll go over the kind of one by one. So the tenant fails to pay the rent. They didn't pay the rent. Now, in normal times, the landlord serves the tenant with a notice to pay rent or quit. Usually that's going to be a 3-day notice. Right now, as I said before, that notice must comply with SB 91 and the COVID-19 Tenant Relief Act in order for it to be enforceable. But still the process is still the same, right? Still got to serve a notice. It's just that now there's those additional requirements, 15-day declaration form, that kind of stuff. Now you move on. Landlord must file a copy of the notice with the rent board within 2 business days of serving the tenant. Failure to do so is a defense to an eviction lawsuit. That's still true. Nothing of that has changed. The tenant fails to pay the rent within the noticing period. Now, again, remember the noticing period previously was like 3 days, but now it's 15 days and they don't have to pay the rent, or not all of it. What they would have to do, most likely, again, this is for rent that's owed from September 1, 2020 to June 30th, 2021. They would only have to, one, and that's why that asterisk is there, by the way, so I can remember to explain this. They would have to, one, submit the declaration, and 2, pay at least 25% of the total rent owed by June 30th, 2021. But let's just say they didn't do that, right? Let's just say they didn't, it's June 30th, or sorry, July 1, they didn't pay anything. Well, now you could definitely move on with a potential eviction if that was not, if those things weren't followed. But just, as a side note, if the tenant submits a declaration and pays that 25%, the law says they can never, ever, ever be evicted for that rent. It doesn't mean that that debt is forgiven, right? But in terms of, and there's 2 issues, there's eviction and then there's the debt. This law, the SB 91, is only talking about the eviction. So if they complete those requirements, they can never be evicted for that rent. All right, so again, back to the flow chart here. So then the notice period goes, and let's just say we're in normal times, landlord serves a 3-day notice, they don't pay, then the landlord can file the eviction lawsuit in Superior Court. And this is the first time I'll tell you, and I'll probably tell you this at least several more times during this presentation, the best advice that you can get, the best information, that you can get out of this workshop is, if you are considering an eviction, 100% talk to a lawyer. Like, there's no question about it, especially given the complicated nature of evictions right now, and because of the law and how it's changed. All right. So let's just say the landlord files the eviction lawsuit, or your lawyer, for the lawyer for the landlord files. The tenant must respond with their affirmative defenses to evict within 5 days of having served the lawsuit. Again, some of these things are slightly different, but essentially the process is the same. The asterisk is there because, say, for example, the tenant didn't submit. You gave them a declaration form, but they didn't submit it. Well, under the state law, tenants actually have what we call the second bite of the apple. In their answer, when they respond with these affirmative defenses and all that, they can actually submit to the court their declaration and say, well, I couldn't submit it before because of mistake or inexcusable neglect. There's a few other reasons why the court may accept that declaration. And then if it's, what the court will do is they'll say, all right, well, we accept the declaration, but you still owe that 25%. Let's say they didn't pay that yet. Then what they'll do is they'll give them, I think it's either 5 or 10 days to pay that 25%. And if they do, then the eviction's over, and you can't evict them because they complied with the state law. But again, in normal times, the tenant just must respond within that 5-day window. And let's just say the first alternative, you follow that arrow, right? It says the tenant responds with affirmative defenses within the 5-day deadline. All right, now the court will send out notices of a hearing. It says trial there, but it's not necessarily, quite trial yet, but they'll set up some preliminary hearing dates and stuff like that. In any event, when you go back to this box right here, it says second alternative. Well, the second alternative is that the tenant fails to respond within the 5-day deadline. That's a big mistake by the tenant, because then, as you see, the landlord can file a request for a default judgment. That just says, well, Your Honor, they didn't file the requisite paperwork. I should just win as a matter of law. And that's up to the judge. And if approved, the default judgment is entered against the tenant, right? You follow the box, the arrows there. And if the tenant does not move voluntarily, the landlord asks the court to issue a writ of possession, which they would then take to the sheriff or police, and the sheriff would then serve the tenant with a 5-day notice to vacate. Then the sheriff would evict the tenant, and they're escorted off the property. Now let's go back to this part where we talk about, after the court mails the notice of hearing, then there's a judge, which is also called a bench trial, or a jury trial is held. In most cases, tenants will likely request a jury trial, and whoever requests, the type of trial first usually will get it. So if the tenant responds and says, I want a jury trial, they're likely going to have that. If the tenant wins, they get to stay in the unit. That's it. And if the landlord wins, they get possession back of the unit. That's the only issue in evictions, by the way. It's possession. And it's not, eviction and possession is not about people. It's about the unit. So sometimes landlords ask me this I guess quite frequently, actually. Like, oh, well, this one person is causing a problem, can I evict that person? In most cases, no. Most evictions are for everybody or for nobody. You either evict every person in that place or you evict nobody. That's it, because it's about possession. That's the only issue. Now, the final box there says settlement. It's a smaller box, but in fact, settlements are quite frequent for evictions. They're incredibly common because trials for these kinds of matters are quick, meaning there's a lot of work that has to be done in a short amount of time. They can be expensive, and it's just a lot of work and stress and money, and so generally speaking, most landlord and tenant attorneys will try to settle, and if they can find a way to do that. If they can't, then they'll do trial, but in most cases, it's probably going to settle. Oops. Okay. So this is I just want to go briefly over, so before we went over, the Richmond Urgency Ordinance, it's in effect for, through the local emergency plus 60 days. Then there's SB 91, which is the state law, and those protections for non-payment rent at least go through June 30th. Now this is the Contra Costa County Urgency Ordinance passed by the County Board of Supervisors. And so the latest iteration is Urgency Ordinance 2021-11. Now, initially, the Richmond City Attorney's Office has indicated that the county's order will apply in the City of Richmond. And the county's ordinance does the following for residential tenancies. And specifically these are for fully covered units in Richmond. It prohibits no fault evictions. Now, so first of all, no fault evictions, that's like owner move-in, Ellis Act, or basically any eviction where you're just terminating a tenancy and the tenant actually didn't do anything. That's a no fault. Now, it says there's an exception to that, again, under this ordinance, except for owner move-in evictions for health and safety and Ellis. Now, read in conjunction with the Richmond Urgency Ordinance, the only thing that's different is you can't do owner move-ins right now. Health and safety, a nuisance that's connected to an eminent health or safety or Ellis Act, those are still permitted. The urgency ordinance also prohibits evictions where tenants allow an unauthorized occupant to live in the dwelling unit if the occupant is a member of the tenant's immediate family living in the dwelling unit and the occupant moved in as a result of the COVID-19 pandemic. So, right now, if there's, maybe you see some more people in the unit or something like that, those types of evictions are precarious right now because if, your tenant's brother and his family lost their job and, or whatever happened, and they had to move in with your tenant, you can evict them because, you're saying, oh, well, your lease says only these people are supposed to live here. Well, they moved in because of the pandemic, their immediate family. So you actually can't do that. Now, whether or not, your individual fact pattern will allow it or not, I don't know. In fact, the urgency ordinance doesn't define what immediate family is. So does cousins count, only your parents, do even siblings? I don't know. That's up to the court to decide. And these prohibitions are applicable through June 30th, 2021. And again, we have this information on our website should you need to review it. All right, so no fault evictions, a detailed look at owner move-in and withdrawal from the rental market. Again, owner move-in is currently not allowed, but withdrawal from the rental market is. All right, eviction for owner or ownership relative move-in. So this is where the owner wants to recover possession of the rental unit as a primary residence for the owner's spouse, children, parents, or grandparents. An owner in this section is considered an actual person who has at least 50% recorded ownership. An eviction for owner move-in cannot occur if the same owner or chosen relative already lives in a unit on the property or if a vacancy already exists on the property. Excuse me. Now, at all times, an owner can request a reasonable accommodation if the owner or chosen relative is disabled, excuse me, and another unit is necessary to accommodate the person's disability. Tenants have a first right of refusal to return if the rental unit is ever placed back on the market. All right, so if you move in and that person, let's say you're the owner, or you move in your son or something like that, they stay for 5 years, well, that displaced tenant gets the first phone call and say, hey, this unit is available. Would you like to rent it out again? Owner move-in noticing requirements. The tenant must be served with an owner move-in notice, termination of tenancy. we have an entire packet actually on our website should you want to review some of these notices. Usually the owner move-in forms may be downloaded from our website. Due to the emergency order, contact a rent program counselor to have the forms emailed to you, and also to explain some of the prohibitions right now on these types of evictions. The owner must give the tenant at least a 60-day written termination notice if the tenancy has been in place for more than a year. Now, finally, kind of replaying what I said earlier, within 2 business days after serving a tenant a termination of tenancy notice, the landlord must file a copy of the notice with the rent board with the completed proof of service. Failure to do so renders the notice of termination null and void. I'm not sure if that's actually true. It may just provide an affirmative defense. So the notice may not be considered null and void, but again, I mean, the effect is essentially the same. That, you know, if that's true and they didn't actually file it, then either way, the notice wouldn't matter because the eviction wouldn't go through. Owner move-in requirements of the person moving in shall move into the rental units within 90 days after the tenant vacates and must occupy that unit as their primary residence for at least 36 consecutive months. That's 3 years. So that's a pretty big commitment. The owner must pay 1/2 of the applicable relocation payment. We'll go over those in a second. Within 3 business days after the tenant has informed the owner in writing when the tenant plans to vacate the unit. And it has to be by the end of the notice, right? The remaining half is due within 3 business days after the tenant has vacated the unit. Now, if the owner or chosen relative fail to occupy the unit within 90 days after the tenant vacates, the owner shall, 1, offer the unit to the tenant who vacates, so you got to offer it back, and 2, pay the tenant all reasonable expenses incurred in moving to and from the unit. For rent control properties, if the tenant moves back to the property, the owner may be eligible to apply applicable annual general adjustment rent increases. The landlord must provide tenant with proper noticing requirements for rent increases. But remember, you know, you can't go to market. Like if they say, yeah, I want to move back in, you can't say, all right, well, market rate is now this. You can't say that. It's based on their previous rent that they had when they were evicted, plus any of those AGAs. As it says at the bottom, the non-rent control properties, right? If the tenant moves back to the property, the owner may apply rent increases. The landlords are not restricted to AGA rent increases. The landlord must provide tenant with proper noticing requirements for rent increases. That's under state law, but essentially the rent itself can be increased to essentially whatever you want as long as you give proper notice. Protections for seniors or disabled persons from owner move-in. So an owner may not evict for an owner or owner relative move-in if the tenant meets the following criteria. 1, has resided in the rental unit for at least 5 years, and 2, is at least 62 years of age, disabled, or is certified as being terminally ill by the tenant's treating physician. However, there's a way to kind of override that protection. An owner may evict a tenant who is protected if the owner or chosen relative also meet the same criteria and no other units are available. So, you know, if you have a senior tenant and they say, well, I'm protected, I've been here for 5 years, I'm senior, the landlord could, in theory, say, well, I'm also senior, right? I don't really know. It's kind of unclear about the 5-year part. It says the same criteria. Unfortunately, there's not much clarification in the rent ordinance about this. It's like, you know, I don't know if that means they would have to own the property for 5 years. It's kind of unclear. But either way, I think the intent here is that if the owner kind of matches the tenant's status, I guess you could say, like, they, you know, they're senior or they're disabled themselves, then they could potentially override that. But all those issues will still have to be hashed out in court. All right, so moving on, the Ellis Act, withdrawal from the rental market. Again, This is one of the very few evictions that are, essentially like just untouched. It's a very strong state law. So the Ellis Act is a California law that provides landlords in California with a legal way to get out of the rental market business. The Ellis Act was adopted by the California legislature in 1985 after the California Supreme Court decision in the case of Nash v. City of Santa Monica. And we'll go over some of the relocation payments in a second, but just remember, withdrawal from the rental market, the relocation payments are very high. So they are an expensive eviction. So, just giving you a little bit of forewarning. So first of all, the tenant must be served a written notice for withdrawal from the rental market or termination of tenancy. The owner must give the tenants no less than 120 days for the tenants to vacate the property if there is not a qualifying tenant who lives in the household. The owner shall provide a written notice to each tenant on the property, notifying them of the withdrawal from the rental market. Tenants, now this is the notice part, tenants shall be entitled to a 120-day notice, that's 4 months, unless they are qualified tenants. Qualified tenants are entitled to a 1-year notice if they are senior, disabled, have at least one dependent minor child, or are considered a low-income household and have been residing in the unit for at least 1 year prior to the date of delivery of the notice of intent to withdraw. So again, these tenancies have to be at least 1 year, and they have to either be senior, disabled, have to have minor children, or be considered low income. If any of that is true, then they are entitled to not 120 days, but a 1-year notice. If a qualified tenant wants the 1-year entitlement, they don't just automatically get it. They'd have to say it within 60 days of the date of the delivery of termination notice. The qualified tenant must return to the owner a notice of entitlement to a 1-year notice. Basically, they have to say, I've been here for a year, I'm a senior, or I have a child, I'm entitled to 1 year. And then the landlord has to issue a brand new notice, not 120 days, but now a year, okay? All right, returning withdrawn rental units back to the rental market. For rent control properties that are being withdrawn from the market and are rented again after withdrawal, the following applies. So if the property is offered for rent within 2 years from withdrawing from the rental market, the owner shall, 1, be liable for actual and punitive damages to any tenant displaced by the property being withdrawn. So that's a big deal. That means you cannot rent. If you LS the property, you cannot rent for 2 years, straight up. You can't do it. If you do, and the tenant finds out, you're going to be liable for all kinds of damages. And so, it's highly recommended to talk to a lawyer about these things. But, I can just tell you from my own experience that you definitely should not, try to do that. LS them and then just go right back to renting. It could subject you to all types of liability. 2, they also have to offer the unit back for rent to the displaced tenant. And that asterisk there is if the tenant says at the bottom, if the tenant has advised the owner in writing within 30 days of the displacement of his or her to desire to consider an offer to renew the tenancy and has furnished the owner with an address to which that offer is to be directed. Second, for the first 5 years, so the first part we were talking about the first 2 years, now we're talking about the first 5 years after withdrawing the rent unit. If the property is re-offered for rent, the property shall be offered back to the vacating tenant at the rent in effect when the property was removed from the rental market. So again, for 5 years, if you try to re-rent it, you first have to offer it back to the displaced tenant and they get their old rental rate. Now, it says, if you go on, it says the annual general adjustment rent increase may be applied if the tenant moves back into the rent unit. So if they say, yeah, I want to move back in, they would get their old rental rate plus any applicable annual general adjustments, but you cannot go to market. That's a big deal. Now, if the property is demolished, reconstructed, or offered for rent within 5 years from the withdrawal of the market, the newly constructed units shall be subject to rent control, right? So if you demolish it and you build up new units, it's not going to matter that, they were built with permitted and, certificate of occupancy after 1995. None of that matters because you LS the property and then built these units. So they're still going to be subject to rent control. Now, finally, if the property is offered for rent within 10 years from withdrawing from the rental market, the owner shall notify the rent board and offer the unit back to the tenant who was evicted. So all you have to do is offer it back to the tenant, but they don't get that same rental rate anymore. So again, there's 3 windows: 0 to 2, 2 to 5, and then 5 to 10. Now, find that big part at the bottom, the tenants have a first right of refusal to return if the rental unit is placed back on the market. So, all of these points just really go to show you that Ellis is a very complicated, very restriction heavy, very expensive type of eviction. And only if you really does fit your needs should you really consider it. But that said, if you have questions about it, our staff can talk to you about some of these like facts, some of the law, but what we cannot do is give you legal advice. And so again, that is always going to be reserved for your own attorney. And I highly recommend you speak to one prior to instituting this type of eviction, simply because there are so many restrictions. All right, now I'll go briefly over the Richmond Relocation Ordinance. So there's temporary relocation payments, where the landlord must provide relocation payments assistance when 1, the tenant must temporarily vacate for the land to undertake substantial repairs, if there's a governmental order to vacate, or if the tenant is forced to vacate due to conditions of health or safety, even without a termination notice. Notice of entitlement to temporary relocation payment must be provided with the notice of termination of tenancy. So you have to tell them they're entitled to this. And relocation payment amount is determined by a resolution of the city council. So we don't have anything to do with it. It's all determined by the city council. So these are the amounts for temporary relocation payment for 2021. So as you can see, hotel or motel, it's $161.99 per day per household. Meal expenses are $32.61 per day per person. Laundry is $1.08 per day per household. And if they have pets, that would be $31.53 for a cat, $56.54 per day per animal. And again, this is if the pet accommodations are only applicable, not just if they have them, but if they have to put them up in a boarding house or something like that, right? So let's just say they have to stay in a hotel, but they don't allow pets. Then that means the tenant has to put them up somewhere. So that's when the pet accommodation payment would be required. All right, permanent relocation payments. So this is where these payments must be provided to tenants whose tenancy is terminating due to owner move-in or withdrawal from the rental market, or under extenuating circumstances due to governmental order to vacate or health and safety conditions. The notice of entitlement to relocation payment must be provided with the notice of termination of tenancy for owner move-in and withdrawal from the rental market. And the amount is determined by a resolution of the Richmond City Council. So these are the amounts to be paid based on, for 2021, based on the bedroom size. So for a studio, the base amount would be $37.96 and 32 cents. 1 bedroom, $58.61 and 91 cents. For a 2 or more bedroom, it's $79.82 and 93 cents. If you see on the right side, it says qualified tenant household amount. A qualified tenant household amount, as you see on the very bottom there, is any household that includes at least 1 tenant that is a senior, disabled, or has at least 1 minor dependent child. So if any of those are true, they would get that qualified tenant household amount, which is just higher. The second kind of box there is for withdrawal from the rental market. Again, that's Ellis. So again, you see the amounts there. Obviously, you can see they're higher, much higher than owner move-in. So the base amounts are $76.48 and 9 cents for a studio, $11.77.23 and 82 cents for a 1 bedroom, and then $15.9.10 and 42 cents for a 2 or more bedroom. And as you can see on the right side, there are also qualified tenant household amounts: $87.64 and 59 cents for a studio, $13,509 and 99 cents for a 1-bedroom, and any 2-bedroom or more would require $18,310 and 84 cents. All right, these are just some final important tips on evictions. The most important tip, like I said previously, is to talk to a lawyer. And you just need to speak to a lawyer about most of these things because they are super complicated, and each situation is different. And so one small fact here or there can totally alter the analysis. So super important to talk to a lawyer. But I'll give you some other things as well. So a self-help eviction is when a landlord locks a tenant out, cuts off utilities, or otherwise takes their own action to terminate the tenant without going to court. Self-help evictions are illegal in California. They are highly frowned upon, in fact. So you cannot lock tenants out, cut off the utilities, or do anything else to try to evict that tenant without going to court. A landlord must proceed with the unlawful detainer, that's the eviction lawsuit process, and receive a judgment from the court. If the tenant does not vacate, the sheriff can evict with a writ of judgment in their possession. Self-help evictions, if you perform that, it's illegal, and it subjects you to all types of liability, where the tenant can sue you for tons of damages. So they are highly, legal, and they subject you, and they're just really risky because they just put you in such a precarious position of liability. Evictions can be highly technical. It is highly recommended to consider speaking to legal counsel to better understand the process and current law, and to possibly have the attorney represent you in court. Learn about tenant and landlord responsibilities and educate yourself about both California and Richmond eviction laws. That last part is super true. Anybody here on this webinar, anybody going to our website, anybody speaking to our staff, counselors, it is super helpful to really get a better sense of, how to do these things, because there's a lot of law, there's a lot of risk, there's a lot of cost, and there's a lot of potential liability in these actions. That's why it's super important to educate yourself and to speak to professionals to further understand. No-fault evictions such as owner movement and withdrawal from rents market are complicated. No-fault evictions require special noticing, permanent relocation payments, and provide special rights to the tenant, such as the right to move back in at the rent paid when the tenant vacated the property, and protected status for a qualified long-term tenant. And again, just as a reminder, owner move-ins pursuant to the Richmond Moratorium are currently not allowed. Take evictions seriously. That's for both landlords and tenants. They're not something to, kind of put off to the wayside or think you can just do it yourself. I mean, you can do it yourself, technically. Both tenants and landlords can represent themselves in court, but, it's just not recommended to do that. Contact the Richmond Rent Program as soon as possible if you receive threats of eviction, warning notices, actual termination notices, example, a 15-day notice to quit, 60-day notice termination notice, or court documents for unlawful attainder. If you are a landlord, contact the Richmond Rent Program if you're considering issuing any of these notices or documents. The eviction process has firm deadlines, which, if not met, can lead to the tenant being evicted. If an unlawful detainer complaint, eviction lawsuit is received, tenants generally have only 5 or, as I said earlier, or 15 for non-payment rent days to respond with an answer to the unlawful detainer. That's why that asterisk is there, because usually it's 5, but currently for non-payment rent, 15. If a tenant does not file the answer to the unlawful detainer with the court within the allowed time, the judge may enter a default judgment against the tenant. Be a tenant in good standing. Prior to a just cause eviction protection in Richmond, tenants could be evicted without cause. Tenants should avoid giving the landlord a just cause reason to evict by being mindful not to violate the lease, cause a nuisance, deny lawful landlord entry, or damage the property. All right, so I just want to thank everybody for attending. I know that was quite a lot of information. I understand that, these things can be complicated. You probably have a lot of specific questions. Unfortunately, as I said in the beginning, I cannot answer legal advice. And for more complicated questions that I may need, that our staff or myself would ask, further details, I think it's just better if you contact our office and we can set up an appointment to, really dive deep into your situation and, explain as much as we can about, the law and, how the process works. So I'll hand it over to Cindy to start our Q&A session.
Thank you, Palomar. That was awesome. So it looks like we have 9 questions.
Okay.
So the first question is, a landlord who wants to sell his house after June 30th, how to serve a proper notice to the tenants, wants to know how to serve a proper notice to the tenants, and what if he wants to sell it as a vacant house? So I guess they're probably wondering maybe eviction due to the sale of a home.
Right. So as I said before, how to give notices and what to do in your specific situation, that may be considered legal advice. I can't really dive into that, unfortunately. There are particular notice requirements for different types of evictions, but as I said earlier, you cannot evict a tenant because you want to sell the property. It's not a just cause to evict in Richmond. So if you want to sell the property, go ahead. There's nothing preventing you from selling that property. It's just evicting the tenant pursuant to the sale. That is what is not allowed. Now, there are other options, stuff, there's like all kinds of stuff you could, if there's other reasons to evict that are allowed by current law, or, there's even the option of buyout, stuff like that. That's always the option. But if you just want to sell the property and you want to evict those tenants just through the sale, it's not going to happen.
Okay, can a landlord serve a notice of non-renewal after June 30th?
I'm assuming what that means is, can you terminate the tenancy after the lease has expired? Again, I perceive that that's what that means. So as I said before, mere expiration of a lease is not a just cause to evict. You cannot, say, oh, well, your lease is up. Again, these are for units that are covered under the just cause for eviction protection. If there's no just cause, then yeah, you do whatever you want, basically. It's follow state law, but for our program and our law, you definitely cannot say, well, your lease is up, you need to get out now. The only exception to that is the temporary tenancy just cause, which, as I previously stated, is only applicable for single family homes where the owner has previously occupied that house as their principal place of residence, and then says to the tenant, here's this lease. In the lease, it specifically says you have to move out at the end of this. It can only be for 12 months at max. That's it. So that's the only exception to the, this rule that you can evict for expiration of the lease.
Next question, will we be able to do the rent increase for 2020 that we did not get to do in 2021?
It's a good question. That's a policy discussion that that's beyond my pay grade. That will have to be discussed with the actual, rent board, or, the policy makers in our agency, which would be like the executive and deputy directors. I surmise that there will be something like that. Obviously, to just deny landlords that would be wrong. I don't know how it's going to roll out, though, or when, or all that, but I surmise that yes, you will be. I mean, first of all, just to clarify, even before the pandemic, landlords who had previously unapplied AGAs can catch up anyway. You can quote unquote bank AGAs so long as the banking complies with, I believe it's regulation 602, I think it is. In any event, we have caps on how much you can bank, which is usually the current year's AGA plus 5%. So if you had a bunch of AGAs that you haven't applied over the last like 4 years, You probably couldn't apply all of them at once, but you could probably apply like 2, and then you do the other 2 like the following year or something like that. So that's probably what's going to happen. It's not like you lose that AGA just because you didn't apply it 1 year.
Next question, should a landlord file eviction papers to a tenant monthly for non-payment of rent, or is filing one time enough?
So first of all, I can't give you legal advice. I can't tell you what you should or should not do. Second, filing of eviction papers and serving notices for non-payment of rent are totally different, right? Before you go file an eviction in court, you still have to give proper notice depending on what type of eviction you're actually pursuing. So for non-payment of rent, and I, surmise that that's what this question is about, not actually the filing of paperwork at the court. If the tenant owes rent for any particular month, then yes, you would want to serve a 15-day notice for non-payment of rent, but that notice has to comply with the COVID-19 Tenant Relief Act and SB 91. You have to, have that language in there. You'd have to provide that declaration form. The tenant would only be required to pay 25% of the total rent by June 30th. And if they do that, for each of those notices, they send a declaration and they pay that 25%. They can never be evicted for that rent. Now, remember though, that they paid 25%. So what about the other 75%? Well, the state law doesn't forgive that debt. It doesn't say, well, tenants are just forgiven forever. That's not what it says. In fact, it says the complete opposite. It expressly states that this debt is not forgiven. In fact, opens up the courts for landlords, specifically small claims court, to pursue debt that is owed due to COVID-19 from their tenants. And specifically what it says, so previously small claims court had rules that said you can't file more than one case over $2,500 and your claims can only be up to $10,000. Well, the state has changed those rules and said you can file as many as you want for however much as you want in small claims court, but the first time you could file for those cases, any debt, would be August 1st. That's the first time you can go to small claims court and say, well, they owe me all this debt. Now, there's an added complication to that as well, because last year, Richmond had its own moratorium, which predated the current one, the one from last year. And then we actually had a repayment period for a year. And so before the state passed its own laws, that meant, because the Richmond order lasts until September 30th, so that means that there was a 1-year repayment date, so they would have until September 30th of this year. But the state law actually changed that, and it said, well, any repayment period passed by a local jurisdiction can pretty much only go to August. So August 1 is now the kind of operative date. So they have until then to pay back any of the rent that was covered under the Richmond order last year. And then if they don't, then that's when you can go to small claims court.
Okay, the next question is, can a tenant under current regulations breach the lease without danger of eviction? I guess that depends, right? I mean, lease agreements are contracts. There's all kinds of provisions in there that they could potentially breach and be evicted. For example, like you have a pet. It's not a service animal. It's not an emotional support animal. It's just a pet. And your lease says no pets. That's a breach of the lease. You could be evicted. But other provisions, like I said earlier, like, occupancy limits, this unit is only reserved for these 3 people, and it names them, right? But as I said,
Like, for example, the Contra Costa County ordinance said, well, you can't evict people for bringing in immediate family who had to move in due to the COVID-19 pandemic. So even that has its limitations. So it really depends on what the lease says, and it also depends on which particular provision you're trying to say that they breached. So yeah, you just have to look at those two issues and then talk to a lawyer about, what are your potential options. And if you're a tenant, then you'd have to say, well, let me look at the law and let me see, are these actionable items? I got a dog, my lease says can't have pets. Well, that could be a problem, right? That could be a breach of the lease. He could be at risk for a potential eviction.
Okay, next question. If a tenant is not paying rent and comes into the office for other reasons, are we allowed to ask the tenant why they are not paying rent?
I'm sorry, I didn't understand that question. Can you repeat that?
If a tenant is not paying rent and comes into the office, I'm assuming our office, for other reasons, are we, the person who's asking the question, allowed to ask the tenant why they are not paying rent?
I mean, I think what that question is really asking is, can you ask for proof of why they're not paying rent? And the answer is no. If the state law says all the tenant has to do is submit that declaration and pay the 25%, that's it. You cannot ask for like proof that you lost your job, or that something, whatever, that you can't ask for it. The state law just expressly says that. The only exception to that is if the landlord already has independent evidence and knowledge, or knowledge that tenant or tenancy is what's called a high income tenant. So if you already knew, for example, that your tenant, worked at, like Google or something and was an executive at Google, they are well above, and by the way, they have to be above the median income, they have to be 130% over the median income. So they have to be well over, I think the limit is $100,000. But you cannot ask them, how much do you make? You have to already know that they are a high income tenant. If you don't know, or that they are not a high income tenant, then you cannot ask for proof or any other information about why they're not paying rent. The state says all they have to do is submit that declaration and pay the 25%, and that's it.
Okay, it looks like it was a clarification, not proof, just why they are not paying rent at all. No declaration completed, will not fill out form at all.
Oh, so that's a totally different question. So if they don't fill out the declaration, then they are potentially not, protecting themselves from eviction. Like I said before, there are certain reasons why a tenant did not submit the declaration, but the state law says they can do it. They get a second bite of the apple. They can actually submit the declaration directly to the court in their answer. So let's just say tenant doesn't pay rent. Landlord serves a notice. They don't submit anything. And then June 30th passes and they still didn't submit the declaration. Landlord files, serves the tenant. Then the tenant responds with an answer and their declaration. And they say, Your Honor, I made a mistake. I didn't know that I had to serve this declaration back, blah, blah, blah. Then it's up to the judge to determine and decide if they, agree with the tenant. And if they do agree, then what they're going to say is, okay, well, I accept this declaration. But since it's after June 30th, you still have to pay that 25%. And I'm going to give you, I think the law is 10 days. I can't remember if it's 5, it might be 5. It's 5 or 10 days to pay that 25%. And if the tenant does that, that's it. Now that eviction is over because they satisfied the requirements under the law. And they submitted their declaration, the court accepted it, and they paid their 25%. Now that eviction is over. But if, for example, the tenant responds, doesn't submit the declaration, or the court rejects their explanation as to why they didn't submit it, then you can proceed with that eviction and they could potentially be evicted.
Okay, next question. Is there some type of cheat sheet that shows side-by-side comparisons for areas where regulation and laws are different for single-family residents versus multi-units?
I don't know if there's a specific cheat sheet that fills that description. We do have our fact sheets on our website. And if you look online, there are like lists of different jurisdictions and how they kind of play out with rent control. You know, not every city in California, in fact, most cities in California are not rent controlled. It's only kind of like the larger cities that generally would have rent control. But for our purposes, you know, we can look at our fact sheets. But if you want to just look online, I have seen some, you know, lists of different jurisdictions and how they compare. Generally, just so you know, though, single family homes, single units, condominiums are just going to be partially exempt anyway, even if there's a rent control jurisdiction, because state law says so, right? The Costa Housing Act, which was passed in 1996, says, you know, these types of units just can't be rent controlled, you know, just generally. There are some exceptions to that, but, you know, again, to answer that question directly, I wouldn't know off the top of my head. You just have to look it up.
Okay, next question. If a tenant stopped paying rent before the pandemic and paid a couple of months during the transition period and then stopped, what happened? What about that? What if a tenant stopped paying rent before the pandemic and paid a couple of months during the transition period and then stopped?
So that's really two questions. You know, the rent prior to the pandemic, you know, that's different, right? Because the SB 91 and the COVID-19 Tenant Relief Act only covers rent from March 1, 2020 to June 30th, 2021. If they owed rent prior to that, then that rent is not covered by these rules and restrictions and requirements, right? You'd have to definitely talk to a lawyer, because now, you know, if you're talking about like January 2020, you know, that's a long time beforehand. And so, you know, I don't know how to really, you know, play that out. Now, in terms of the second question, if they've only paid a little bit during the transition period, then they still have until June 30th, right? The law doesn't say they have to pay it by the end of their month of their due date every month. It says they have to pay 25% of all of the rent due by June 30th. They could theoretically wait till June 30th and pay it all that day, and that's it. They're safe. There's nothing wrong with that. So really, you just have to kind of wait and see. Unfortunately, that's just the way the law is written.
Okay. Next question. Late fees, are they covered as well in March 2020 to June 2021?
So the latest iteration of SB 91 prohibits the application of late fees for non-payment of rent. So, you know, I think before SB 91, it was AB 3088. Now that law didn't prohibit late fees. So maybe then you're good. But now you can't do it. The state law says you just can't add on a late fee or a late charge for non-payment of rent that is covered under SB 91. Can't do it.
Okay, I'm gonna see if I understand this question. If an owner communicated with the tenant telling them that they need to move out by a particular date, she understands that they understand that it triggers requirement for relocation, but the tenant chooses to send a written notice informing the owner they will vacate, will that require the landlord to pay 50% and then the full amount at the move out? And is security deposit return involved in that process?
So nowhere in that question that I hear why the landlord would be evicting. But since you've mentioned relocation payments, I'm assuming this would be for owner move-in or Ellis Act. First of all, owner move-ins can't do them, currently prohibited. If it's for Ellis, then yes, you're right that in fact, the law says that in order to get that first half of the money, the tenant would have to say in writing to the landlord, you know, I agree, I will vacate by the end of this notice. And then within, I think, 2 or 3 business days, the landlord
it was mentioned that it is about an OMI.
Okay. So yeah, so like I said, OMIs are not allowed. But let's just say they were, then yeah, the tenant would have to tell them, I agree, I'm going to leave by the end of this notice. Then that triggers the 2 or 3 day window to pay the first half. And then once the tenant vacates, then they pay the other half. That's kind of it. I think that answers the question. Did I answer the question?
It sounds like it.
Okay.
The next question, but if they have more questions, they can always contact our office.
That's right.
So the next question is there not accommodation for an elderly landlord who wants to do an owner move-in?
Yeah. So like I said, here I'll try to go back on it real quick. Hold on one second. So if you're doing like an owner move-in, I think that's what you said, right, Cindy? Owner move-in?
Yes, owner move-in accommodation. So is there not accommodation for an elderly landlord who wants to do an owner move-in?
Right. So, you know, first of all, it wouldn't even matter if there's no protected tenant in there, right? The tenant would have to be protected first, meaning they would have to be in there for at least 5 years, and they would have to be 62 years of age, disabled, or certified as being terminally ill to be insulated from an owner move-in eviction. And in that circumstance, if the owner is also senior, disabled, or certified as being terminally ill, then they could potentially override that protection and do the owner move-in. Again, this is in normal times, right? Like, again, I have to repeat that these are currently prohibited. But the first issue is, you know, well, I guess there's 3 issues. One, can you do it right now? No. Let's take that away. Let's just say it's like later in the year, and this prohibition is over. Then you have the second issue is, do you even have a protected tenant? Have they been in there for 5 years? Are they disabled? Are they 62? Are they certified terminally ill? If no to any of those questions, then it doesn't matter what you are, you could just still do it. But if yes, then the third issue is if the owner is also one of these criteria. And if so, then you could potentially move forward with that eviction. Again, you know, these can get complicated, so definitely speak to a lawyer about it.
I think it was they were. Oh, so the tenant can decide to leave even if it's not allowed to evict currently. Will that relocation payment be enforced by the rent board, or question mark? That was in regards to the one you just answered.
Oh, yeah, I guess so. Yeah, I mean, you can't just say, well, they're prohibited right now, but they moved out, so I don't have to pay anything. No, that's not true. If there's an OMI, even though it's currently prohibited, let's just, you know, say that, you know, you gave them the notice prior to this law being passed, and maybe you want to execute. I don't know. I mean, it really depends on the fact. But if an owner move-in is performed, then yes, you still have to pay that relocation payment. There's no way of getting around that. Absolutely.
The next question is there a requirement for relocation payment for OMI that can be enforced without going to court?
Yeah. So OMIs are, if I'm an owner and I serve, let's just say this is normal time. I'm an owner, I want to move in. I give a 60-day notice. They tell me I want to move, I'm going to move out. I have to pay that first half, period. There's no court involved yet, but they tell me, yes, I'm going to move. So then, yes, it's required. And then at the end of the notice, they move out. No court, but they moved out pursuant to my notice. You have to pay that. Court is only there to enforce your notice, right? Let's just say they fight you on the owner move-in. They're like, I'm not moving, or I can't move yet, or whatever. Then you go to court. Then you have to try to enforce that termination notice. Either way, you would likely have to pay that relocation payment. Doesn't matter. The point is that if you perform this type of eviction for owner move-in or Ellis or any other thing that requires relocation, you have to pay it, period.
I think you answered this earlier, I'm not sure, but it says, are late fees protected along with rent payment outlined in lease agreement, release agreements during the protected period, March through June 2021? I think you answered that earlier, but this person's asking this question.
Right. So, even it doesn't matter if your lease says I can charge a late fee for non-payment or late payment of rent. Now you can't do that. You just can't. The state has said there's a late fee provision or anything. You can't do that. You cannot charge for non-payment of rent, right? You cannot charge a late fee for non-payment of rent because of the passage of SB 91.
Okay. Can a landlord increase rent in a community where there's no rent control at this time? Meaning, for example, a condominium community?
Good question. And so that kind of relates to the Contra Costa County's urgency ordinance, right? Which is in effect through June 30th of this year. And it says you cannot do residential rent increases through that date. However, there are exceptions. And some of those exceptions are what you asked, which is like single family homes, condominiums, new construction. Those type of properties are not covered by that prohibition. There's an exception to that type of that prohibition. So in theory, those types of rent increases can proceed.
And last question, are landlords allowed to add restrictions to lease agreements, such as no smoking, and would a breach of that provision be subject to eviction?
Good question. You cannot just change a contract unilaterally, right? A unilateral change is a one-sided agreement. Remember the kind of the theory behind contracts that two parties have this meeting of the minds and they agree to what is in that contract. But if I enter into a contract with Cindy, for example, and she says, all right, well, these are our terms. And I say, great, these are our terms. I can't then go behind her back and then add in a bunch of stuff without her consent, right? That's not a contract, at least not that part. That part's not enforceable because she didn't agree to it. And the same is true for these kinds of, issues. Like, can you just add in stuff? No. Now, if you ask the tenant, hey, I want to add in this provision, is that okay with you? Well, we actually have some language. I can't remember off the top of my head if it's in the ordinance itself or in our regulations. But basically it says if you want to add in new things, you first have to, inform the tenant what you want to add in. You have to also inform them that they need not sign on to the changes, that they don't have to sign on to it. But if you do that and they still are like, sure, I'll sign on to it, then no problem. That's totally fine. But again, the issue comes up when you just add it in or scratch things out. You definitely can't do that. Those parts are not going to be enforceable if the tenant, violates it. And then you say, oh, well, see, I added this in. I'm going to try to evict you now for breach of the lease. It's not going to happen.
We do have one more question. If a tenant didn't know they qualified to get relocation costs, but finds out after moving, can they still get paid? What's the time limit?
Great question. Potentially, yes. I believe that the statute of limitations for our petitions are generally about 3 years. So that means that you would have a is that right, Cindy?
Oh,
That
I
would
believe
mean,
so.
yeah,
Three
so you would
years.
have right. So you would have a 3-year window to file a petition with us for relocation payments. Now, the other option to that has nothing to do with the rent program, but you could actually talk to a lawyer about, seeing if that's a better way to try to enforce your rights to those payments. Now, there's ups and downs to both options. The upside of going through the petition process that it's basically, it's free. You don't have to do it, pay for anything. You can represent yourself. You can say, I got this notice and I moved out. Here's proof of all that. And I didn't get paid. You could potentially have a decision in your favor. The downside to the petition process is that, we are not court. And so we can't really enforce these matters. The only way we can enforce it is say, well, the landlord is out of compliance and they wouldn't be able to evict or raise rent potentially. But, those types of decisions are subject to appeal by a landlord. Say the tenant wins, landlord appeals, now you're going to court anyway. Or sorry, you're going to the rent board and then you're going to court. So there's all this process. Now, if that's the downside to that. And like I said, the upside is that it's free. The upside to going to court and talking to a lawyer about instituting your own private right of action would be that you have, potentially additional claims. There's all kinds of different stuff that you could potentially ask for, not limited to just those relocation payments. The downside, the other upside is that they're heavily enforceable, right? Because if it goes to court and there's an order that's issued by a court, so it's largely enforceable. The downside is that you probably have to hire a lawyer, and those can be expensive, hard to find, and plus the process in court and trials is it's very difficult and can be just very long and very arduous, very emotionally taxing. I used to do litigation myself in these kinds of affirmative cases, and they're not quick. They're not a few months. These are like 6 months, 1 year, 2 years, going on for just to get some of that money back. So you'd have to kind of prepare yourself mentally for the long haul, but it does have its advantage, like I stated previously.
That was the last question.
All right, so we can give it a few more minutes to see if anybody has any follow-up questions.
If you don't mind changing your screen to the contact information.
Sure, sorry about that. There you go. So we'll wait a couple minutes.
We have one question. What legal agency can we refer tenants to who are being threatened with eviction?
Great question. Well, first of all, you can always reach out to the rent board or the rent program. We have counselors on staff who can answer most, if not all, of your questions. We can't give legal advice, but they can kind of go through your case and give you some potential options. And the other thing is that the counselors can also give you referrals to a couple specific legal agencies that we work with, such as the Eviction Defense Center or Bay Area Legal Aid. You can also, reach out to those places directly if you want, but we do work with them pretty closely. We have a contract with these agencies, so you can definitely. It may be more advantageous to reach out to us because one, we can go through some preliminary questions, and two, you may get an actual referral for these agencies, which they tend to prioritize over people just like kind of cold calling their office. So the first step, probably just give us a call. If not, then like I said, you can reach out to the Eviction Defense Center or Bay Area Legal Aid.
Okay, so we have 3 more questions. So basically there's absolutely no exceptions to relocation payments for OMI.
Nope.
The next question, can the rent board get involved in the tenant? Can the rent board get involved if the tenant is on Section 8?
I'm not sure what that means, get involved. I guess it depends, right? Generally, Section 8 tenants are partially exempt. So, their rent's not regulated by us. They are regulated by the housing authority. So if it's something to do with rent, that would not be us. But if they are covered under just cause for eviction. So if it's eviction related, maybe. But just remember that it just is a general rule. The rent board doesn't get involved. It's not like we represent tenants. We don't represent landlords. So I don't know what that means really. Potentially there could be some informal mediation or something like that. But I guess in an example where we would get heavily involved would be if a tenant, because they're covered under just cause. So let's just say an owner does an Ellis Act, right? But then they don't pay the tenant the relocation fees or payments. Then that tenant could file a petition with us saying, I'm owed this money. Then we would obviously be involved.
It was clarified for mediation. Yes, mediation.
Yeah, that's potentially, yeah. Right now we're definitely not doing formal mediations. We're doing, some informal mediations, and also it depends on the case. But it's not like we would just say, oh, Section 8, we're just not going to do it. I don't think so. So, the best way to go about that is to just give us a call, send us an email, say, hey, rent program, this is what I'm thinking. Is this possible? And then we can go from there, because it's kind of hard for me to say yes or no at this point.
The next question is about you mentioned about they can contact, a legal referral, and this person is saying that tenants are getting voicemails it's hard to reach a person at those agencies. Do we have a contact for nonprofits? But I can answer this one and let them know if it's in regards to a particular issue, it's probably recommended that you call our office, speak to a counselor. And like Palomar mentioned earlier, they can actually give you a legal referral. And that means we can send it over to that agency, so that way they can reach out to you personally. So it's probably best, if you have an issue, it's probably best for you to call directly to our office, speak to a counselor, so that way they can refer you. So, we give out numbers that we have provided already on the website. So if it's in regards to a particular issue, it's probably best that you just contact us directly, so that way you can get a legal referral and get in.
Yep. Yeah, absolutely.
The number to speak to a counselor is actually on our screen. It's 234-7368. Or you can actually send us an email at rent@ci.richmond.ca.us. It's also available in the chat.
And yeah, these agencies are nonprofits, and especially right now, as everybody on here probably understands, like housing and rentals, it's a big, complicated mess. And these agencies are being flooded with calls and asks for help and representation and assistance. So, they're people just like us. They have limitations. They only have so much staff and so much budget. They can only do so much. And so, you just kind of got to be patient. But that's why Cindy explained that it's definitely a great idea to call our agency, because if you talk to us and then we believe it's a good fit for referral, then that agency will prioritize your request and reach out to you. The fact that they you have to leave messages. I mean, that's just going to be common. Unfortunately, they're just probably inundated with, all types of work right now. So I do second the idea that, anybody who really wants to speak to these agencies and are not getting any luck, call our office and we can kind of guide you through the steps and information, and then potentially refer you out.
That's it right now. If anyone else would like to, ask a question, we ask that you please put your questions in the Q&A section. You click on the bottom portion of your screen, you'll see Q&A. You can click on that and include your question. Please do not put your questions in the chat.
Yeah, we'll give it like 1 or 2 more minutes to see if anybody has any final questions. And if not, we'll just end it. And like I said, and Cindy said, you can always give us a call or email us. It's probably the better way to really get some in-depth information. This is just kind of, this workshop is just a broad overview of some of the things regarding evictions, laws, and stuff like that. But, really the best kind of meat advice is really to talk to someone, either our staff or someone we can recommend to you, to really get an in-depth analysis as to what's going on with your specific situation.
Maybe he's having issue, the person's having issue putting the question in the chat, in the Q&A section, but I'll ask you real quick. Is a subtenant protected in Richmond?
Absolutely. There's no real, under the law, there's not much of a distinction between subtenants and tenants. Subtenants generally carry the exact same rights as tenants. They're tenants too, It just means that there's a certain financial relationship that, in between them paying the rent direct to the landlord, there's another person. But that's all that means. It doesn't mean they have less rights or more rights or anything like that. They have essentially the exact same rights.
No further questions right now.
All right, we'll give it like another 60 seconds. Just any final question? We'll take like one more and then we'll call it.
I did get one question.
Okay.
I don't understand. I'm going to try to explain it. How can a landlord appropriately ask a tenant what their intentions are in regards to when they are able to pay the balance of the rent? Is serving eviction papers really necessary, and without the tenants feeling harassed?
I mean, serving eviction papers is, for non-payment of rent is different than just asking, hey, what's going on? That I can't tell you what you should or should not do or how to do it. That's legal advice. But, if you're a landlord and you want to ask your tenant something, go ahead. If you want to find out, they're not required to answer or give you any information besides what is required by law. But I don't think there's really any harm in just asking, hey, what's going on? And that's, I think that's fine given, the circumstances of the pandemic and everything that's happening. Every fact pattern is different. Every housing situation is different and very unique. And every relationship every tenant and landlord relationship is different. I'm a fan of open communication between tenants and landlords. I'm just not a fan of either landlords or tenants, kind of like the question asked, harassing each other for it. Now, where that line is, it's obviously unclear. There's no real clear, bright line. It just depends. But if you are in good faith, just giving an email and saying, hey, I just, kind of want to know what's going on without having to provide specifics, I don't think there's really anything wrong with that. It just depends on how you say it, how many times you say it, when do you say it, all that stuff. Generally speaking, you should just put everything in writing. You're a landlord and you're calling your tenants like, hey, what's going on? Just stop that, just put everything in writing. Remember, and I think that most landlords don't really see it this way, but just remember, rentals are a business. It's not anything else but that. And so you need to treat it as such. You need to be, very meticulous with your paperwork and documentation, just like any other business. Your financials and all that all has to be documented. So everything should just be in writing, period. And that's just a general, just good rule to practice, so yeah.
You have two more questions, and I believe that will be it.
Yep.
The OMI chart shows a base rent and a qualified rate, a base rate and a qualified rate. If a property is occupied by two tenants and one is qualified, is the OMI relocation expense the base plus the qualified amount or just the higher amount?
Great question. No, it would just be the higher amount. You can never get both the base plus the qualified. It's either the base or the qualified. But if any one single tenant is any of those categories, senior, disabled, they have minor children, then they would get the higher qualified tenant household amount, but they wouldn't get the qualified tenant household amount plus the base amount. It's one or the other.
Okay, last question. Is there or will there be a landlord registry for single family rentals and or multifamily corporate rentals or in the City of Richmond or Contra Costa County? I don't know if you know that question, but.
Yeah, I definitely wouldn't know about the county. Single family homes, condos, like all those kinds of units, we don't ask too much in terms of registration for the tenancies. We do ask that landlords enroll. Currently there is no registry. That there are some legal complications there, but I don't know the answer to that question. Currently there is none. And I think they said something else. It said registry about landlords, and what was the rest of the question, Cindy?
They just asked, what are the, let me go back to it. Is there or will there be a landlord registry for single family rentals and or multifamily corporate rentals in the City of Richmond or Contra Costa County?
Right. First of all, I don't know if there will be, there might be. I don't know. It's very hard for me to predict the future. It's not, I'm not a policymaker. I'm one of the staff attorneys, so I don't deal with that. In terms of corporate stuff, again, our agency only deals with residential tenancies. I don't know exactly what that means, but if it's a commercial unit, that's just not our agency. So I don't know how to answer that.
And then a part of that question is, do landlords have to register their rent? Do they have to register to rent their properties? They have to enroll.
Okay. Yeah, great question. And that'll be the final one. Yeah. So if you're a landlord in Richmond, generally you have to enroll, period. Got to do it. Registering is usually about the tenancy information. So who lives there, what the rent is, what the service is, that kind of stuff. That's only required for fully rent controlled units. Units that are partially exempt or fully exempt, that is not required. You don't have to register the tenancies. So you don't have to tell us any of that information. But if you're a landlord in Richmond who rents either a partially or fully covered unit, you definitely have to enroll. That's for sure. So I think that's it. I want to thank everybody for attending. I hope you found this information useful. Like I said, and Cindy has repeated, we have plenty of information on our website. We can set up counseling phone calls, Zoom appointments, whatever you want. Just follow up with us at the contact information below, or sorry, at the screen. And I want to thank Cindy as well for assisting me today. So thank you, Cindy, very much. And I hope everybody has a great evening. All right.
Thank
All right.
you for attending.
You guys take care.